Yes, you're right. I apologize.
That was your fault?
Technically not. Technically.
But we're in. You're all set. Court does call the case, People State of Michigan versus Joseph Wilson.
On behalf of the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Wilson, who is approaching the table.
Merci. All right, this is your motion, Mr. Bernstein.
Thank you, Your Honor. Most of my arguments are contained in the written motion that the court has, I know, has reviewed. I just have, I guess, a couple of updates and maybe a little background. A lot of what went into Mr. Wilson's thinking that day when he went to plea, he was faced with a situation where his family was embroiled in separate cases, and it was really, it was really tearing them apart. It was really making it so that life just couldn't keep going on that way. And the way he looked at it is he wanted to do something for the family as a whole that would benefit them. And in his mind, he thought that the mature thing to do, the right thing would be to sort of sacrifice himself in a way and plead to this so that things would cool down. And that was
when you say separate cases, you alluded to that in your motion and brief, but I don't know what that means.
There was like two cases going on. One of the cases didn't involve Mr. Wilson directly, but it involved children. It
involved who?
The children, his children, Your Honor.
All right, but was that a criminal case or
juvenile case?
Black?
A criminal juvenile case.
Okay.
One of the children was accused of assaulting the other child.
Got it.
And one of Mr. Wilson's parenting duties was to accompany the child who was assaulted to the WCAC for therapy. And Mr. Wilson believed that this plea would help cool things down for the family as a whole and benefit everyone.
How so?
Well, Your Honor, as the court knows, every criminal case involves a certain amount of tension. It involves a certain amount of uncertainty. And that tension and uncertainty isn't good for a family. It's not good for the individuals. It's not good for the whole.
I get that, but I guess when part of what was, at least I got from your motion, was in defendant's mind, right or wrong, in defendant's mind, somehow by entering this plea, he believes something was going to happen. What is that something?
I think he thought that would bring the temperature level down amongst the children. And instead of putting someone on the stand who is already going through a lot, he was going to plead and prevent that from moving forward. And in doing so would bring those temperatures down, Your Honor.
Okay.
It unfortunately for him, it didn't work out that way. He found out soon after taking the plea that he was no longer allowed to bring his son to the therapy. He was able to obtain from the Washtenaw Child Advocacy Center their user manual, which says that they have a requirement that if you are accused of these sorts of things, you are not allowed at the WCAC. And so he's no longer allowed to be the one that
you're accused or convicted.
Alleged to be. That's what it says. That's what the email says. Alleged to be perpetrators. And they sent me the manual.
Well, then nothing changed from the plea.
Well, the email says unless they're cleared. So you can be alleged and then they require you to be cleared from it. I understand the court's point, though.
Right. I mean, he was alleged to have been from the beginning of this case.
That apparently did not stop him from being able to take son to therapy.
Okay, go ahead.
Oh, it did? Oh. Well, so I just be corrected, Your Honor. It did prevent him from going to therapy pre-plea, I guess. So that's what Mr. Wilson just said.
Well, then that negates the other part of your argument, doesn't it? Because his status, if pre-plea, his status was he couldn't take the child to counseling. And post-plea, he can't take the child to counseling. Nothing changed from the plea.
Well, I get that, how that hurts my argument. I didn't quite know that before I drafted my motion and brief, Your Honor. Nevertheless, he does find himself in a situation where he just won't be able to accompany his son to therapy moving forward. And it's very difficult for him and the family moving forward, given that. Yes.
That's why I had them bring this from the chart. The other two, because I thought that if we moved him from the charge, because I didn't get charged against him, I got charged against just the charge.
The plea itself, Your Honor, was, as he was charged originally, I guess we weren't terribly clear on which child it related to, but he made sure that the plea did not relate to the younger child, that it related to the older child, so that he would be able to, at that point, take the youngest child to WCAC for therapy. And that's what his hope was, given the plea, but it did not work out that way, Your Honor.
And now I'm still lost. Because again, as I read the motion, and I'm not sure that this collateral consequence would be one that would matter to the court in its assessment. But he wasn't, one of the results of the plea was that he wasn't able to take his child to counseling. However, that existed prior to the taking of the plea. That has existed throughout the entirety of the case. Right?
Correct, Your Honor.
The other thing that I was curious about, and you haven't mentioned it, I don't know if some indication of a threat.
Threats
That he.
Oh, on the day that he pled?
Yeah. Well, that's not clear to me.
I think one of the things that went into Mr. Wilson's mind, but to be fair, it goes through a lot of defendants' minds when they come to preliminary exam, is the threat of additional charges that could be added after exam. That's something that a lot of defendants face when they appear in court. But that's something that went into his thinking too, and that's why we included it, Your Honor.
Okay, but are you talking about that the prosecutor may have said, we're gonna add these additional charges if we go for it? So are you saying that's an impermissible threat?
I'm not saying it's impermissible. I think I'm saying that it's pretty common in these situations when clients show up to preliminary exam that could be a thing. So in conceding that it's very common, I think I'm trying to telegraph that it's not impermissible, Your Honor, but it's just one of the factors that went into Mr. Wilson's thinking on the day.
Okay. All right. Anything else?
I'm just hoping the court takes into account the various factors that we put into our motion and brief, Your Honor. Thank you.
Thank you. Response.
Your Honor, I too am going to rely largely on my response and brief in support, but a few points of clarity. My understanding in working with the CAC is that the offending parent, whether convicted or not, cannot bring the child to therapy. This is a process and procedure the CAC puts in place for protection of children, also protection for their own employees. Whether that is right or wrong, or could sometimes be negative in terms of the child, that is their policy and procedure. So I think that it appeared the defendant kind of stated that himself, he wasn't allowed to bring the child to therapy in the beginning. And I think even if he hadn't pled and say this case had been dismissed, I'm not certain he would be able to bring the child even then, because there was still a charge against him and he was still, quote unquote, the offending parent. So if the child continued in therapy, I still don't think that the defendant would be able to bring the youngest child to therapy. I also just wanted to address kind of the repeated statement in defense's motion about extreme pressure and threats without any real support for those statements. I did speak with Mr. Bernstein on the morning of the exam and informed him that, as is well within my right, if testimony comes out that there is probable cause of additional abuse, that I would be adding a charge. That is not a threat. That's well within my right to inform him of that. It was not a promise. It was just a statement that I made, that I had spoken with one of the victims that morning and he had explained to me what he had seen, and I was going to ask him about what he experienced in the home. If probable cause came out, I was going to ask for additional charges. I do not think that defense has met their burden, that this plea can only be withdrawn in the interest of justice and for fair and just reasons. To me, it really seems like defendant is now simply unhappy with the plea and wants to withdraw it, and that is not a fair and just reason for withdrawal. I think this court and all courts benefit from certainty in pleas taken under oath. I did copy and paste a direct segment from the plea that he confirmed under oath he was not threatened. This was of his own free will, of his own choice. I think some of the statements in the brief that he had waited all day are really kind of self-imposed restrictions, because I was ready to go in the morning. These are long days, and sometimes we are not able to get started until the afternoon. I had made the offer for child abuse fourth early in October. I don't know when, obviously, that was communicated to defendant, but I think he had plenty of time to consider that offer, consider any quote unquote collateral consequences he might face. Ultimately, I don't think they have met their burden of presenting fair and just reasons for withdrawal. So I would ask that Your Honor please deny the motion.
What would, if I were to find that first portion, I guess, what would be the prejudice to the people? If I were to allow him to withdraw his plea?
Yes. I mean, we do have it is correct that there is a juvenile in this case who had his own juvenile criminal case. That child is now not living with defendant or mom. My understanding is that relationship is very much severed. So I would need to bring that child back, who is now adjusting to a new home. I think doing well in that adjustment. Certainly has some trauma and some things that we would bring up again if he were to testify. So I think that is my main concern, and the substantial prejudice that the people would face is that bringing back a child who also had to sit here all day with his family. He was here from 8:30 until 4 p.m. when this plea was completed. And I think that goes beyond just inconvenience. This is potentially kind of causing further emotional injury to a child who has, admittedly done some bad things, but this is a child, and we'd be bringing them back to testify, tearing them again from a family situation that appears to be working out for them. And I have concerns about doing that, and I believe that is substantial prejudice the people would face.
Fair.
Thank you.
Bernstein, anything else?
I don't know if the court would allow Mr. Wilson to say a few words to the court.
You want?
He's asking to make a statement, Your Honor.
Go ahead.
The prosecutor is saying that she doesn't want to bring this child back because of further damage to him. But she, I would like to remind her that she didn't have a problem with bringing a 6-year-old child in who was molested by this other child.
Hold it, sir. I asked, the response that the prosecutor was giving was what prejudice, if I even make it over the first hurdle, what prejudice would be caused to the people's case? I don't know that you're responding, or quite frankly, what I at least see as the first portion of an attack on the prosecutor, it is going to help the court in its analysis.
I will not do that. The day that I took the plea, it was a very long day and repeated throughout the day. And even before that day, I said I would not take a plea. And the day it did, it dragged on for almost 8 hours. And me and my lawyer, we spoke and we talked, and we talked about different things that could or could not happen. And my wife, who was at work that day, left work to come here and even had conversations with her. And I had to make a decision. Do I want my wife to have to stand in front of the court and talk bad about her own child? Did I want to stand in front of the court and have to bring up with what this child did to, what my stepson did to me and my wife's child? And as I sat there and thought about it, I didn't want to stand in front of the court and destroy a 13-year-old who was my stepson, who I love. You know, I didn't want to stand up here and have to attack his character to prove my point. I didn't want my wife to have to go through it. I didn't want my 6-year-old son, who is having a extremely tough time with adjusting. He has.
But that's now changed for you?
Well, in my mind, I thought I didn't know the full policy of.
Hold it. No. You raised an issue of subjecting these children to something.
Yes.
So, but then you're asking me to withdraw the plea,
Yes, because
which then potentially subjects them to that. So that's changed for you?
So to help my 6-year-old, who's now 6, he is having a tough time coping with what happened to him by the other child. He has been taken out of his normal classroom. He has been put into.
No. You're telling me that at the time that you took the plea, what factored into it, I don't know if that's going to matter so much for the court, but I'm trying to understand what you're trying to tell me. That what factored into that was not causing, I would just call it additional emotional trauma on these children. But now today, you're asking me to allow the withdrawal of your plea and this matter to proceed, I guess, to preliminary exam, but those same things would occur.
Now for the 6-year-old. So the 6-year-old, I have to start making him the priority. The 6-year-old won't have to come forward. The 6-year-old needs to get his therapy, and my wife cannot take off. He's missed tons of therapy because she can't always get off work to take him to therapy because she's at work during the time that he's supposed to be in therapy, and I can't take him. And my understanding is that
but you never were able to take it.
well, initially I was able to take him, so I started off taking him.
But that's not what we were just told.
So on April 31st, my stepson did something to my son. Therapy, and I initially was the person that was taking him. And then a few months later, my stepson accused me of something. And then after that, then they said I couldn't take him anymore. So in my thought process, when I took the plea only with, initially had both children on there. I took the plea with only the older child on, thinking that they would allow me to bring my son now because I don't have a charge specifically against me with him. And that is why I took the plea, because I thought that if I took it with only the older child's name on it, I would then be able to take my son again. But when I got home and
There weren't two counts, though. There was only one count, ever.
and even that, so when I got here that it initially, I was told that it was against the younger child. When I got here that morning, all of a sudden they had the other child here, and then they said, "Oh no, we're charging you with him," and it's confused me that day, like completely. But I didn't understand how it switched from one child to the other child morning of.
I don't think anything switched. Because I've only got one count.
It was initially against Josiah Wilson. Eventually, it switched to Jordan DeMoss. My final charge was with Jordan DeMoss. He was the one that came to that way.
Your Honor, I will say that there's not a listed victim on trial.
I know.
It says minor child.
It says just one minor, it says a minor child.
Correct. And Your Honor, there were in the police report accusations for both children.
Correct.
My understanding is that the younger child has communication challenges and I don't believe would be able to testify. So that was why we needed the testimony of the older child, and why I stated that there might be an additional count should this child testify to abuse that they received and that the younger child possibly received.
I'll let you go on, sir.
Yeah, so at this point, like I am trying to figure a better way to, I thought this was the correct way to help my family, but it is not the correct way. So, it did help my wife and the older son's relationship some. They are communicating a lot better. And some of those things are working out, but the 6-year-old who was the victim, it has not helped him. He has suffered the most. And like I said, he has been taken out of his normal classroom, put into a special classroom because of behavior that all started after this incident. And he's been diagnosed with PTSD and he needs therapy, and I can't afford for him to miss any more therapy. And if it's at the cost of my wife or my stepson, that would just have to be the cost. But I can't continue to let my 6-year-old suffer and not make this therapy based on trying to protect the child that hurt him.
Good. Thank you. Anything else, Mr. Burns?
Your Honor, to be fair to Mr. Wilson, I think he's doing a pretty good job of explaining what's in his mind. And if that does or does not meet the criteria of motion withdrawal of plea, that's one thing. And I think what he's trying to describe is what I was trying to communicate to the court at first in argument, is that what he thought he was doing was for the benefit of the whole. And it seems like, fortunately, there has been some benefit to that. So he wasn't off the mark on that. And I'm really happy to hear that. But it seems like it hasn't quite gotten the family unit to where it needs to be. And that's why he's in front of the court now. He's trying to do what he feels and what he sees as the right thing to get help to his son. He's motivated by trying to help his son. And that's why he's coming before the court now to try to withdraw his plea, Your Honor.
In reading the defendant's motion and hearing argument, well, what is clear is that the plea may only be withdrawn where it is in the interest of justice to do so, and there is no prejudicial effect on the people. I guess the best way to describe it, and I mean, maybe it's an overbroad statement, but the defendant, its motion, and even somewhat here today, there seems to be a plenty of reasons why he believes that his plea should be permitted to withdraw. This court doesn't find that any of the things that have been said would be in the interest of justice to allow this plea to be withdrawn. There are indications that there was a threat, some type, and initially it stated don't know specifically from whom. The defendant may have felt some pressure, outside pressures to collateral matters, but those aren't threats that are leading necessarily, or I should say legally cognizable reasons as to why the defendant would have pled no contest to this charge. Every defendant that comes before the court has their reasons for entering their plea, and they vary. But in this case, the defendant has that reason of this sort of whatever threat, which this court, quite frankly, doesn't believe that that was any threat at all, or that there was a threat. Court specifically inquired whether or not he was being threatened or coerced in any way to enter the plea. Defendant responded under oath that he was not. There's also this issue that the defendant raises in terms of time. Well, Ms. Willingbringer, as she indicates that they were ready to go. I understand on these days, on the preliminary exam days, that yes, they can get long for everybody here, and particularly for the court. But I would also note that this court's practice, and it has been for years, not decades, during preliminary examinations, is that if the case is ready to go, I'll call that case. I mean, not necessarily for an exam, but certainly for a plea. So nothing held the defendant here regarding the court's practices to not allow him to enter a plea. If the exam needed to go forth, the exam would have gone forth. He would have been in line. So I don't buy that argument either. I mean, I'll have people here at 5 o'clock and we'll start their exam. And it sometimes just happens that way, but I don't believe that led the defendant to do anything. I think, quite frankly, one other point, there is this notion that somehow or another, there are these children that will not be able to benefit from something if this plea stands. I don't have anything in writing, but I will rely upon what is being said to the court. The defendant wasn't permitted or isn't permitted to take the child to counseling. Somebody else's rule. But he knew that before the plea was entered. I don't know how one would think that that would change if the plea is entered. That just doesn't make any sense whatsoever. The collateral consequences and what's been pointed out to the court are nothing more but defendant's buyer's remorse as to the entry of a plea in this case. There was a deal given. He had adequate time based upon the time frame that I see in the motions in which to think about that. He certainly had the benefit of counsel in regard to sorting all of that through. And he made his choice. I don't believe that, given everything that I've heard and in reading the memorandums and briefs and motions of the parties, that it is in the interest of justice to permit this plea to be set aside. I don't need to reach, I do believe, I don't need to reach that whether or not there's prejudice to the prosecutor in this case, although I do believe that there would be, as the prosecutor has described, but I don't think I need to reach that question. The defendant's motion to set aside his plea is denied. Sentencing will continue on
March 12th.
March 12th before Judge Barr.
think we have a February 20th date, Your Honor.
I thought it was adjourned off of that there, but if you have a February.
Just trying to help for scheduling. We already had that date and it's been adjourned to track with this case.
Right, but I don't know if they adjourned it.
They did remove the 20th date and put it for March 12th.
Okay, thank you. That's good.
It looks like it was a scheduling error, the 20th, it's not.
So sentencing is actually March 12th.
Yes.
Thank you.
Thank you. What
Thanks for your
time?
time, Your Honor.
9 a.m.
9 AM. Thank you.